homeless since the 1st of August, and we're in a class of society that is the working poor. Like, my partner has a job, works full-time, we still can't find a place to live, so we've been...
I don't have references, so then when I go to a place, it's all, well, where were you living? I was living on the street. Oh, well, I'm sorry, we don't have room for you here.
I think it says something like notice to illegal campers, telling them to vacate and telling them there was nowhere else they could go. Some days after that, the campers stayed, and some days after that, they were served with court documents, writ, statement of claim, alleging that they were violating various portions of the city's parks regulation bylaw and the streets and traffic bylaw. So the city had a court date, and they were going to court to get an injunction, and Kathy and I, with help and assistance of many of our dear friends, colleagues at the university and students, worked like crazy. We're down at Bridge Park taking affidavits. People were forthcoming, telling us their stories, and we went to court at the end of October to resist the injunction. And the type of injunction that the city sought, we call it a statutory injunction, and it's very hard to resist it. It's pretty much automatic. The judge heard us out. We said, Judge, there's really important constitutional questions here. This needs to get before a court. Now, the judge in that case was Mr. Justice Stewart. He granted the injunction, but we got a bit of a win. He noted in his reasons for judgment that because there had been very similar cases in Vancouver arising out of the Woodward Squat and tent cities over there, he was basically bound to issue the injunction. He had to kind of follow the precedential law. So he issued the injunction. But he limited it. He limited it to a period of 10 months. And in his decision, he quite notably, in our view, said that he was limiting it to that time period, and this is a quote, in an effort to see that the plaintiff, i.e. the city of Victoria, has some interest in getting the trial heard. So that was the first judge to hear this case. He said, this matter needs to get before the court. So we went on, and time passed, and things didn't move along very quickly. And Kathy and I, on behalf of our clients, who were the defendants in this action, they were being sued by the city, we consulted with the counsel for the city and said, look, when are you available? We're going to set down the trial. So we got a date, and we set the trial down for September 4th, 2000, and set down to be heard at that time. Now, that summer, the summer of 2007, in July, we were writing to the city. We were asking for clarification on how they interpreted their bylaws, precisely what they relied on, and so forth, etc. But on, I think it was early in July, the exact dates don't really matter, the city served us with court documents, which basically was an application within this action, and they were going to go to court and seek a permanent injunction, not the 10-month limited one that they had already got. They went to seek a permanent injunction based on what we call the property offenses. Now, just to clarify that for you, the city was saying that the people camping in Bridge Park were in violation of the bylaw that prohibited loitering and erecting a temporary abode. They also alleged that there were contraventions of other bylaws, and those bylaws included things like injuring or destroying turf, depositing waste or debris in a park, selling or exposing, this is one of my favorites, selling or exposing for sale or gift refreshments. So that was really bad that they did that. Carrying a firearm or weapon, okay, fine, we weren't doing that, but anyway, and obstructing the free use and enjoyment of Bridge Park by any other person. So these became known as what we call the property offenses, and the significance of that is that property offense violations wouldn't trigger charter rights, constitutional rights. So if the city were to have succeeded in this, I think the strategy was that they could enforce their bylaws, or they could prohibit camping, because I guess the argument would go, put your tent up so you ruin some turf, so we're not going to remove you for tenting, but we are for damaging the turf. So they were seeking a permanent injunction here, which would have, in effect, maybe accomplished what they wanted, and kept the charter arguments, the constitutional issues, from being argued in court. That would have become moot. So we, of course, we opposed that application. We were before Justice Johnston in August, and he heard argument that went on all day on that one, the city's application, and ruled in our favor. So we managed to succeed again. In that application, Justice Johnston said that to grant the injunction that the city wanted would be, and this again is a quote in his words, not just, not convenient, and not appropriate. He went on to kind of say that the property offenses, which is what we had argued, were inextricably intertwined with the other charter issues, and he would not grant an injunction. Again, noting that the matter was set to go to court and the charter issues should be adjudicated on. So, there was one other little quote here I was just going to give you from Mr. Justice Johnson, and what he said was that the application was, quote, rather carefully crafted to avoid seeking an injunction to prevent folks sleeping in public places. And he did not give them that injunction, of course. So, fine, now we're at the end of August. Remember, we have our trial date set for September. We're ready to move ahead and basically argue the charter issues in September of 2007. And on August 29th, the City of Victoria filed a document called a Notice of Discontinuance. Basically what this is that they were plaintiffs in the action. A plaintiff in a lawsuit can choose to discontinue it pretty much at any time, not absolutely, but they can discontinue it and walk away from it. And we said, whoa, that's not fair. These people have been waiting since October of 2005 to have their arguments heard in court, and the city is trying to walk away from it. So that meant that we had to apply to the court this time around, and our application was to have the city's notice of discontinuance set aside. So we went back to court again, and this time around, this was, I think it was around September, or yeah, very early September. We got before, in this instance, the master of the court, Master Keeley, and made our arguments, and we basically argued that we were too far into the litigation for the city to do this, that there's a term that says that the plaintiff is dominus litis, like they are the dominant person in the suit and they can walk away from it. But there comes a time when that's no longer the case, when the defendants have vested interest. And we argued that it was an abuse of the court's process for the city to be embarking on this path. Master Keeley agreed with us. He set aside the notice of discontinuance. He said the city was no longer